Hi, it's October 17th, early afternoon. I want to give an update on my lawsuit against the Minnesota Attorney General, Keith Ellison. We were in court this morning, and some things happened, but the wheels of justice don't necessarily move at the same pace that the practice of medicine might move if a person has appendicitis. And I guess that's not saying a whole lot. But I just want to lay out a quick update. First off, right now I am involved with two lawsuits. The first one is against the Minnesota Board of Medical Practice in a federal district court, basically stating that the Board of Medical Practice infringed on my First Amendment rights of free speech. I'm indicating that the Board of Medical Practice, perhaps inadvertently, regardless, did not make a distinction between my right to free speech as a senator, as a candidate running for Minnesota governor. They did not make a distinction between my right to free speech versus professional conduct as it relates to the practice of medicine, which the Minnesota Board of Medical Practice does have jurisdiction over. So in other words, if I'm providing healthcare services to people and not meeting the standard, or the board is receiving complaints, that's absolutely in their jurisdiction. But my speaking on the Senate floor or doing social media videos, running for governor, those kinds of things are free speech. That's really what we're doing in that case. I have another case against the Attorney General in Minnesota, and that has to do with, if you will, receiving data about oneself. That's in the state district court, and we had a court date today, and the attorneys met with the judge a couple of times. There was some language put into the record officially, and I have another court date in January of 2024. What's happening with that case is what I'm reporting on today. So I just want to read from my attorney's notes the introduction to our case today. Here it is. The Minnesota Government Data Practices Act presumes that all data collected and maintained by the government are public. And then a few paragraphs later, the government cannot withhold data on the basis that a document contains some data that might be redactable. Rather, government, should redact the data which it cannot provide and provide the data which it can. This is really what's happening with my court case. Basically, we have utilized the Data Practices Act to request information that should be public that connects with me. So if it's got Scott Jensen on it or something like that, we want to see it. This is supposed to be public. Specifically, we want to know what was the connection between the Minnesota Board of Medical Practice and the Attorney General's office. This is important because I'm stating that my First Amendment rights were infringed upon. What we've been doing over the last many months is the Attorney General's office has indicated, we received your request, we're going to send you some information, but we're not going to send all of it. Now, their reasoning for not sending all of it has several layers. One of the concerns they have is that they feel that there's potential that if they release certain documents that connect with me, to me, I might discuss them in the public square. And that's a legitimate concern on their part. That discussion in the public square may cause their staff to be harassed or badgered in some way. And I think that's always a concern when public discussions take place. But I would ask anybody who might be listening to this, please don't be mean-spirited. If you have input that you want to provide to the Attorney General's office, that's your right. But I don't want anybody calling the Attorney General's office and harassing them or threatening them in any way, shape, or form. This is a process that is important. I feel like this is a righteous pursuit on my part. We're talking about my constitutional rights and free speech, and we're talking about the Attorney General's obligation to provide the information to me that connects with me. Now, the Attorney General's office is saying, no, we're not going to provide all of it, but we'll provide some of it. The rationale, as I mentioned, might be what's happening to their employees. Another rationale may be that it might be information that I'm not entitled to. Perhaps it's privileged information between the Attorney General's office and a client that they're representing. I get that. I wondered, how can I make this as straightforward as possible? And at the risk of seeming a little hokey, I've decided to use visual tools. So I want you to think of this bag, everything in this Ziploc bag, as being data that involves my name. That's what we're asking the Attorney General's office for. We want the data that mentions Scott Jensen or is about Scott Jensen. In a manner of speaking, what the Attorney General's office has said is, well, we'll give you some of it, but we're not going to give you the whole bag. So you might say, well, what are you getting? Well, it feels like we're sort of getting some cookie crumbs, some animal crackers. It feels like we're getting something that sort of amounts to peanuts, but really isn't what we want. It feels like maybe we're getting some bland lemonade, but it's not full potency. It feels like we're getting maybe a cup of coffee, but it's decaffeinated without the full body and impact that we would want. And this is representative of what we did get from the Attorney General's office. This was about an email that mentioned my name because a local TV station reached out to interview the Attorney General about a matter that I was speaking to on the campaign trail to become governor of Minnesota. 4 pages of documents, repeat email after email. You know how they're repeated and you get on a stream? And it basically said, we want to get your impression, Attorney General Ellison, because we know Scott Jensen is having an event today, and this specific event was about feeding our families, feeding our future, I should say, about feeding our future investigation. So that's really not what we're hoping to get. What we want is what's still in the bag and not on our computers and in our hands. What I just showed you literally is some thousands and thousands of pages. But we want the good stuff. We want the wine, and we don't want to have to whine about it. We want the full-bodied coffee that's got all the potency that we're asking for. That's what we want. So over the last few months, my attorneys have been working with the Attorney General's office as well as the judge to settle the matter. We're saying the Attorney General's office is obligated to provide to us those documents that are covered by the Data Practices Act, which presumes that all data collected and maintained by the government are public. So I'm entitled to see what's being said about me, what went on between the Board of Medical Practice and the Attorney General's office. Through those discussions, there have been some compromises made. The Attorney General's office has said, okay, we don't think you're entitled to Just really good stuff. And we don't even know what it is because we can't get our hands on it, can't read it. They're saying we're not entitled to it and it might be problematic if they release it. So what they've done is they've forwarded that to the judge. And the judge has a chance to look it over to decide, is this or is this not something that Jensen and his attorneys are entitled to? How much information is there? A lot. How meaningful is it? We can't know. We can't know what we can't see or what we can't read. But we're talking about more than 400 documents, more than 5,000 pages. Well, you can imagine what kind of a burden this puts on the judge, the court system, and everything else. And a lot of this is really bland, lukewarm, and amounting to peanuts. 4 pages for an email that simply says that Scott Jensen is speaking to the Feeding Our Future investigation in various settings. Therefore, the TV station wanting to get Keith Ellison's response, that makes sense. But this isn't what we want. I'll tell you what I want to see. I want to see any correspondence or communication that might have taken place on July 6th, 2020, after I had gone ahead and on July 5th, 2020, posted a video sharing with the world, if you will, millions and millions of viewers, sharing with the world that for the first time in my career, I was being investigated by the Board of Medical Practice. My livelihood was in danger. To me, if I am entitled to see whatever correspondence went on in the days that followed the posting of that video, I think that would represent this stuff, the potent stuff. That's important to me because it might impact on, did the Minnesota Board of Medical Practice simply not realize that there was this line dividing free speech from professional conduct as it relates to the practice of medicine? That's what I'm doing with this whole legal process. I don't want to be investigated anymore, and I want to be able to exercise my rights of free speech. I want to be able to speak to the issues that are being discussed in the public square. If I'm in the Senate, I get to speak my perspective, my opinion. I get to make my comments or my impressions of various policies that are being put in place. But I understand that there are privileged conversations, but it right now feels to me like there's just this deluge of information being dumped on the judge. And we don't want to do that. And the judge doesn't either. So today there were more conversations and more discussions and negotiations. And we're going to make an effort mutually, both sides, to pare down the amount of information that we're asking for and they're holding back. And if we can reduce that by 80%, then it becomes a more manageable amount so the judge can look it over and say, you don't have any right to hold this back from Dr. Jensen. And the judge would say that to the Attorney General's office. Or the judge might say, I've looked at it and this is not information you're entitled to, Dr. Jensen, so you don't get a hold of it. I think hopefully it's clear that this state district court hearing does have impact ultimately on the federal district court hearing and lawsuit with the Minnesota Board of Medical Practice, because in part, we're trying to learn as much as we can what happened. How did things go so awry that I was investigated a half dozen times? And all I was doing was doing my job as a senator and then as a governor candidate. So that's the update. The Attorney General's lawyers, my lawyers, and the judge and the courts, we're trying to work this out so we can get through this Data Practices Act lawsuit And from my perspective as a layperson, I want to get to the matter at hand, which as far as I'm concerned is, how does the Minnesota Board of Medical Practice get constrained so that they don't infringe on my First Amendment rights and yet still be able to do their job, which is to protect the public in regards to my professional conduct as it relates to practicing medicine and providing healthcare services. I hope that helps. Obviously, the summary would be this. There's this huge amount of information. The Attorney General's office is saying, we're not going to give you all of it. We're going to give you part of it. And we're saying, well, that other part could be really meaningful to us. So they've given us more since we pushed, but they haven't given it all to us. And now the judge has had that remainder that hasn't been seen by us and is not being delivered to us by the Attorney General's office. That's in the judge's lap, and it's some 6,000 pages. And the judge is saying, we got to figure this out so we can move through this. Our next court date is in January. I can't help feeling as a layperson as if not just that the wheels of justice turn slowly, but I can't help but feel like, wow, this is the world of lawyering and hours and arguing. And yet at the end of the day, I understand clearly that the Attorney General deserves to have the best representation he can have, and I get the same. And I guess it's just real that lawyers go back and forth, talk with one another, and sometimes the judge mediates that and pushes one side or the other. I am grateful that the Minnesota Board of Medical Practice does their work. They're a vital cog in the protection of Minnesota citizens. I am grateful that the Attorney General's office does their work. And I'm grateful that since they first turned over a batch of information to us, they have provided more information to us. But I will tell you this. I want to know what was said between the two parties, the Attorney General's office and the Board of Medical Practice, in the days and weeks following my decision to publicly post on July 5th, 2020, the fact that I was being investigated for the first time in my career. I really appreciate all your support, all your engagement, regardless of what you think of the lawsuits, the fact that you're listening. I think we need to spread this word far and wide, because as far as I'm concerned, this entire thing is about the critical First Amendment right to free speech.